Hello everyone, welcome back to my channel. Today we are diving into an essential but often overlooked aspect of arbitration: procedural orders. If you are involved in arbitration, whether as a lawyer, a company representative, or even as a party to a dispute, understanding procedural orders is crucial. They are the foundation of a well-organized arbitration process and play a key role in ensuring proceedings run smoothly, fairly, and efficiently. So what exactly are procedural orders? Why are they important? And what are the most common types you will encounter in arbitration? That's what we will be covering in today's video. Let's get started. First, what are procedural orders? Procedural orders are written directives issued by the arbitral tribunal to manage different aspects of the arbitration process. These orders set the rules for how the case will proceed, covering things like the schedule for submissions, the rules for disclosing documents and evidence, the format and logistics of hearings, any special procedural matter specific to the case. So think of procedural orders as the roadmap of arbitration. They give the process a structure and predictability, helping to prevent unnecessary disputes over small procedural issues, sometimes big disputes. Without them, arbitration could become disorganized, with parties arguing over procedural steps instead of focusing on the real issues of the case. Why are procedural orders important? Procedural orders are not just administrative formalities. They serve several critical functions. They ensure efficiency. Arbitration is meant to be a faster alternative to court litigation, and procedural orders help keep things moving. They ensure that parties meet deadlines and follow agreed upon steps, avoiding unnecessary delays. Maintaining fairness. A well-drafted procedural order ensures that both parties have equal opportunities to present their case and respond to the other side's arguments. This is especially important when parties come from different legal traditions, as it helps level the playing field. They reduce procedural disputes. When expectations are clearly defined from the outset, there is less room for disagreements over procedural issues. This can help minimize objections, delays, and additional costs, providing a record for future reference. Procedural orders form part of the written record of the arbitration. If there is ever a need to refer back to agreements or tribunal decisions, these orders provide clarity on what was decided and why. Now that we understand why procedural orders matter, let's go through the most common types of procedural orders that you will encounter in arbitration. One type is the initial procedural orders. The first procedural order in an arbitration is often issued shortly after the tribunal is constituted. This sets the stage for the entire arbitration and typically covers the procedural timetable, deadlines for submissions, hearings, etc., the language of the arbitration, the choice of law and applicable rules, the format of hearings, in person, virtual, hybrid. This first order is critical because it ensures both parties and the tribunal are aligned on how the arbitration will proceed. In many cases, it reflects agreements reached during the first procedural meeting between the parties and the tribunal, preliminary meeting as is often called. Now, orders on evidence and disclosure. One of the key phases in arbitration is the exchange of evidence, and procedural orders guide this process by setting out the timelines for document production requests, how evidence should be presented, rules for handling confidential information, limitations on what can be introduced later in the case. For example, if one party wants to withhold certain documents on the grounds of legal privilege, the tribunal may issue an order deciding whether those documents must be disclosed. Another type of orders are orders on hearing logistics. Procedural orders also regulate the logistical aspects of arbitration hearings. This is especially important in international cases where parties, witnesses, and arbitrators may be located in different jurisdictions. A procedural order on hearing logistics may cover whether hearings will be conducted in person, virtually, or in a hybrid format, the duration and structure of the hearings, allocation of speaking time for each party, the use of translators, transcription services, or expert witnesses. Virtual hearings have become increasingly common, so these procedural orders often include technical guidelines to ensure a smooth online proceedings. Another type is interim and emergency relief orders. Sometimes urgent issues arise before the final decision is made. This is where interim and emergency relief come into play. These orders may include freezing orders to prevent a party from disposing of assets, injunctions to stop a party from taking certain actions, security for costs orders to ensure that a party can cover legal costs if they lose. These orders are particularly important in commercial disputes where assets or business interests may be at risk if action isn't taken immediately. Other type is orders on cost submissions and post-hearing briefs. Once the arbitration is nearing its conclusion, the tribunal may issue procedural orders regarding cost submissions and final arguments. These orders guide how parties should present their claims for legal costs, the format and timeline for final written submissions, whether post-hearing briefs are required. By structuring this final phase, the tribunal ensures that all relevant issues are addressed before rendering the final award. To conclude, to wrap up, procedural orders may seem like a technical aspect of arbitration, but they are critical to ensuring a fair and efficient process. By setting clear rules and expectations, they help prevent unnecessary disputes and keep arbitration proceedings on track. If you are involved in an arbitration case, whether as a lawyer, a company, or an individual, understanding procedural orders can help you navigate the process with greater confidence. If you found this video helpful, don't forget to like, subscribe, and turn on notifications so you don't miss future updates on arbitration and dispute resolution. And if you have any questions about arbitration procedures or need assistance with a case, feel free to reach out. Thank you so much for watching, and I'll see you in my next video very soon. Thank you.